Counsel, I'm going to check with the judges. I will return shortly. Counsel, the judges are ready. Please come to order. All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please come to order.
All right, good morning, everyone, and welcome to the District of Columbia Court of Appeals, our virtual Zoom oral arguments, which are being live streamed for the public on YouTube. We have three cases this morning. The first case is Darren Wendt versus United States. Are the parties ready to proceed?
Yes, Judge.
All right, counsel.
Thank you. May it please the court, Lee Gamis on behalf of appellant Darren Wendt, I would like to reserve 3 minutes at this time. In its rebuttal case, the government first introduced the alibi evidence that Darrell Wendt was with Anthony Anderson in Gaithersburg, Maryland on May 13th. Because this injected a material issue into the case for the first time in rebuttal, it was a new matter, and appellant was entitled to sir rebuttal as a matter of right.
Mr. Gibbons, can I stop you there? This whole notion of what is quote unquote a new matter is an interesting one. I'm not so sure if it's fully fleshed out in our case law. You do reference in your briefs a Second Circuit case, U.S. v. Murray, which talks about quote unquote new matters. And here, I guess walk me through a bit why this is a new matter. And the reason I ask is because central to the defense case at trial was this notion of a third-party perpetrator being Darrell Wendt, the brother, and that it was the brother that was there at the house the whole time, and perpetrated the crimes. And although Mr. Darren Wendt admits to being at the home, he says he wasn't the perpetrator. So I do have some conceptual trouble with the notion that it's new when the government says that they were essentially rebutting what defense put on, defense counsel's evidence, specific point about Darrell's whereabouts, and that therefore supported the defense's central theme that Darrell was the perpetrator.
Well, in the Gregory case, this court defined new matter as, quote, a material issue injected for the first time in rebuttal. And while Your Honor is correct that Darrell Wendt's whereabouts as a general matter were at issue in the defense's case in chief, or the defense case, I should say, The specific allegation that Darrell was with Anthony Anderson and Miss Williams in Gaithersburg, Maryland at Williams and Anderson's home, that was a new matter that was first injected during the government's rebuttal case. I think a good way to conceive of this is, how would Mr. Wendt have gone about introducing Miss Williams's testimony during his case? Her testimony would not have made any sense to the jury or been pertinent unless the jury had first heard the evidence that Darrell had this, in essence, alibi of being at Anderson's house that day. So the defense first would have had to introduce evidence that he was with Anthony Anderson to then turn around and undermine that evidence that, in fact, that was
I want to come back to that notion of how the defense would have made sense of putting on that in their case in chief, essentially. But first, if I stay on the rebuttal, the government's contention is that they were rebutting a specific statement that the defense case put on about where Darrell was in the morning. So is there some sense here that perhaps the door was opened for the rebuttal? And I have a second part. I know this is a long
well, I think it's
let me just get to the second part real quick.
Sorry.
Yeah. Response. I'm sorry. And I guess if we're staying on the rebuttal mode, because I do want to hear the argument that you were making about your case in chief, but we get to the rebuttal. Defense did cross-examine Mr. Anderson's rebuttal testimony, and at that time had in its possession or knew of the information that the defense wanted to put on in SIR rebuttal. This is the information about the cell phone data, which defense argues would have shown the text message that one witness received was on the 19th, not the 13th, the date that the crime began. Was there an opportunity there to cross-examine Mr. Anderson? Because was there some strategic decision by the defense to not cross-examine on that information in the defense's possession, hoping that the government would call Ms. Williams, which they ultimately chose not to do?
Well, as to the first point, we're not.
I know that's like 5 questions, Mr. Kempis, but thank you.
To the first point, we're not saying that the government's rebuttal case was improper, or that we objected to it, or anything like that, or that it didn't properly rebut what the defense had raised during its case. But that doesn't preclude the fact that, or negate the fact that it was a new matter. The specific Anderson alibi evidence was a new matter that we then had the right under Gregory to present our brief targeted SIR rebuttal case on. As to the second question, I mean, we did, defense counsel below did cross-examine Mr. Anderson on various things, including his memory as to when exactly the video was posted. He would not have been the proper witness to cross-examine about phone calls or text messages that Miss Williams received, or Miss Williams's phone records. There's no basis to think that Mr. Anderson would have known those things. That was testimony to adduce through Miss Williams in conjunction with her telephone records. I don't know if that.
Counsel, I think you just said that because this was new and material, your client had a right to cross under Gregory.
Right to rebut.
Right to SIR rebut. Yes, my mistake. But I'm wondering if the statement in Gregory about SIR rebuttal is actually just dicta, right? Because we didn't actually rely on that to reverse in Gregory. What we said in Gregory was that the argument that you're not making, which is that the government's rebuttal shouldn't have come in the first place.
The way I read Gregory is he had two allegations. One was the government's rebuttal was improper, and second was, even if it was, SIR rebuttal was warranted. And in that case, this court said that what the government did introduce on rebuttal in Gregory's case was his entire grand jury transcript, which he had already been examined and cross-examined and redirected on thoroughly during the defense case. And this court said, the rebuttal is unnecessary, mainly because he wouldn't have had anything new to add. He only would have been able to reiterate to what he had testified to previously. There were two holdings in Gregory, and it's the second one that we're interested in. It's this, because this was a new matter, he would be entitled to rebuttal as a matter of right. And this court in Gregory said it wasn't a new matter. You would
right. Well, I'll go back and reread Gregory, but my sense was that the court really did pull those two things apart and only issued a holding on one of them. But put that to the side for a second. You are acknowledging that Gregory has kind of this two components for the right to rebuttal. And one is that the information that's put on in rebuttal is new. And I would be inclined to say that information about where Mr. Darrell Wint was on the morning that these crimes began was new information, but you also indicate that Gregory has this materiality component that shows up in other cases, right? That I think Murray talks about things that aren't tangential. And this kind of gets back to the issue about what the government was doing in rebuttal. If you read the government's closing, the government says this crime doesn't even start until the afternoon of the 13th. And so I'm kind of left wondering why we care about where anybody was on the morning of the 13th. And why this was really material to either to the prosecution or to the defense. And I'm wondering if you can speak to that. Well, I'll ask the government the same.
Sure. The government, I think, in closing, used it two ways. And the first thing to notice is that the government thought it was important enough to put Mr. Anderson on, right? So there's that. The government used it in two ways. One, both as an alibi for the actual crime, and two, to backstop Darrell's testimony, to uplift Darrell's testimony. So as the first thing, the government in its closing acknowledged that the crime occurred or started time between 11:29 a.m. and 3:14 p.m. That's what the government said.
Do you have a page for that? I mean, because I was looking at the government saying on page 40 that at 12:30 everything is still normal.
At 10 on the October 22nd transcript at page 41, the crime started between 11:29 when the phone is going Woodland Drive and 3:14 when the pet resort is calling and they're getting that discontinued signal. It's that time that Darren Wint is going into the house. And in closing, I think it might have been a rebuttal closing, but on October 23rd at page 257, government counsel says, if the crime starts at towards the beginning of that 11:30, that actually helps the United States because, quote, do you know what? If someone is attacking Amy and Philip and Vera at 11:30 in the morning, do you know who it is? Absolutely not Darrell, because he's in Gaithersburg, right? And then they also use it to corroborate Darrell's version of events, the government, I should say. They're arguing, how do we know that Darrell is telling the truth about the morning of May 13th as opposed to Darren's story as to what occurred on May 13th. And government counsel argues, channeling Mr. Anderson, well, I don't remember the specific day. I know it was the day I dropped. And it was the day I dropped my haters hate video. Is he going to remember the date when he talked to him? No, he remembers what happened that day. He remembers very vividly that his friend Darrell was up here with him when the day that it was dropped. What's important to him? The video, YouTube. That's what he cares about. So what do? You go online, you pull it up on YouTube. Thank God for YouTube. There it is, May 13th. Well, shoot, look at that. Darrell Wint is telling the truth. So they're relying on Anthony Anderson's testimony about what was happening that morning, the haters hate video, to corroborate what Daryl said happened that morning, as opposed to what Darren said happened that morning. So even apart from the issue that it helps them alibi Daryl for the crime itself, it also helps them in bolstering one of their main witnesses, Daryl, as to what he was doing that morning, as opposed to what client testified he was doing that morning.
As I recall the testimony, however, everybody acknowledged that Daryl left maybe before noon. And isn't it really more important where he was in the afternoon?
Well, I don't know if it was new. I think that it was earlier in the afternoon, I think 1-ish, to get his child or something like that. But again, no, the morning is very important. The morning, as the government itself said, once our client testified, the morning became very important as to what he was doing. And as our counsel argued below in arguing this issue, she said, this isn't a minor issue. I dare to say this is probably the most critical issue in the trial. If the jury believes that Daryl was at the home of Williams and Anderson those morning hours instead of Darren said he was, we lose. And I think that she was right, because Darren had this other.
I guess I want to repeat my question or maybe clarify it.
Okay.
Couldn't we all agree that Daryl was up in Germantown or Gaithersburg in the morning and still have had time to come down to the Woodland House and participate in the murders there?
I mean, I guess one could parse the record and it wouldn't violate the laws of physics, but it wasn't at all what our, the version of events that our client was testifying to, which had this very specific, we met at the parking lot, we went to these different places. I guess that's consistent with what, physically consistent, but it's also not at all what Daryl Went testified to. Daryl Went had this other version of events that he testified to. So
can I follow up a little bit on that question from Judge Fisher, Mr. Gebbis? If putting aside the newness, whether it was new or not, or whether in terms of the materiality and the way that the trial judge weighed this potential rebuttal and surrebuttal evidence, part of the theory of the defense counsel was that this is a crime that couldn't have been done alone by Darren Went, that it required more people, and therefore it was the other two brothers, Daryl and I forgive Stephen Went, to do it, right? So even if I guess I'm having trouble seeing why this proffered surrebuttal testimony was capable of refuting the government's rebuttal evidence. You had Williams and Anderson testify that Daryl is at their house in Gaithersburg on the 13th in the morning part or the early part of the day, at a time when some events were set in motion for a 2-day murder kidnapping spree. So I just don't necessarily see why showing that a text message that Ms. Williams talked about, she may have received. And I do think that was somewhat equivocal testimony, as the trial court found, because someone usually texted her, Daryl usually texted her when he arrived in Gaithersburg. She couldn't recall specifically, I don't think, or as I read her testimony. How does showing that she didn't get a text until the 19th rebut what Anderson and Williams said, which is that Daryl Went was there on the 13th, where you also have the other corroborating evidence that this Haters Hate video was in fact dropped or uploaded on the 13th. So I guess they don't necessarily, it's a nice, perhaps additional thing, but it doesn't squarely refute or doesn't squarely show that he wasn't there on the 13th.
So no
It shows
one.
19th too. That he may have sent a text on the 19th,
So
but-
what,
wasn't there on the 13th.
so it's not only Ms. Williams' grand jury testimony, but also her phone records. And I don't think it was equivocal. She said, did he either text, the prosecutor asked it either in grand jury, did he either text you or call you prior? He texted me. Daryl did, yes. So she has two affirmative, yes, he contacted me before.
What page are you on? Sorry.
Boy, of the grand jury.
Yeah, there's more to that testimony though. When they ask, how does she know? She says, well, because he usually did that.
The government, I mean, the government has sort of glommed onto two things, the use of her word believe and the use of her word usually. You know, looking at her grand jury testimony throughout, she uses the word believe quite a bit. She believed that Daryl drove was his girlfriend. That's on page 11 of the grand jury. She believed that Daryl's child was in elementary school, page 10. She believed that Daryl's child got out of school at about the same time as her child. That was on page 10. So she's using believe throughout. And she also, in this context, only uses, she says, I believe he called only in response to the government prosecutor's question, as best you can recall. So, I mean, the grand jury is sort of already an unnatural, sort of stilted environment where people often use words like believed or to the best of my recollection, especially when the prosecutor prefaced or included in her question as best you can recall. It's only at that point that she says believe. So I don't think the use of the word believe gets the government where it wants to be. And then the government also points to usually, but she says usually, not sometimes, half the time, could have been, maybe. She says he usually calls or texts when he arrives. And then you can consider that in connection with what the phone records show. We're not disputing that at some point in mid-May, Daryl went to Gaithersburg to watch music videos at these people's houses. We're not saying that Mr. Anderson made that up. They're just mistaken as to the date. And when you look at Ms.
Well, but there is evidence, I'm sorry, Mr. Givers, to show that the day they watched that particular video was May 13th. That's other evidence that,
Well, the
that
evidence-
seems to May 13th date is all I'm saying. So even if there was a text on the 19th,
but there was
I don't see that refutes that he was there watching the video on the 13th. I'm sorry.
Well, because there's only one communication from Daryl's phone to Miss Williams's phone during that relevant time period, right? And she says he usually calls or texts before he arrives. And there is, in fact, a text during that time frame, and it's on the 19th. Miss Williams never said, in fact, in the grand jury, she specifically said, I don't know exactly where he was on the 13th, Daryl. I don't know exactly where he was on the 14th. And the government's proffer was not that Miss Williams would then testify, oh yeah, it was the same day that Anderson uploaded the haters hate video to the YouTube. She wasn't going to say that either. And Mr. Anderson was also was not the most solid witness as to when it was uploaded. He didn't even know what time of day he had uploaded it. He thought it might have been that morning, but he couldn't really remember because it had been 3 years. Let me grab that transcript site because I think it's important. On the 1017 transcript at 3:04, he thought maybe he had dropped the video in the morning, but he was just kind of guessing because it had been 3 years. And he also testified that he didn't just post the video and then never see it again. He'd go back and rewatch it, see how many views it had gotten, etc. So we're not saying that Mr. Anderson never showed Daryl this video. We're just saying that Miss Williams's testimony called into question the date that occurred. Because again, she's saying he usually calls or texts beforehand. He came over at some point in mid-May, and the only communication relevant to that, in that relevant time period was the May 19th. She said that she did communicate again with Mr. Daryl Went, but that was after our client's picture had been on the TV and had been arrested and those sorts of things. So the only communication during that mid-May time period that we're concerned about was on the 19th. So when you combine that with her testimony that she believed he called or texted that day, because that's what he usually did, then it's a strong inference that Mr. Anderson was mistaken as to that Daryl came over the exact same day that he had uploaded the video, as opposed to several days later.
Can I ask you sort of just a more abstract legal question? I mean, I find our cases on this issue to be quite thin. There's Gregory that we talked about earlier. There's Chabi, if I'm pronouncing it correctly, and Bynum, which I think both are cases where it's an issue about a defendant's admission against interest, right? And so that hearsay aspect has a different component to it, where, you know, the ability of the speaker to explain what they meant or what they actually said is important. There's canon where the testimony had already been stricken, so we said, well, you don't have a right to surrebut that. That's kind of all we've got. And I guess one of the questions that I have is, do you think that the right to surrebuttal completely overlaps with the right to present a defense and a right to confront witnesses against you? Or is there ever a separation between the right to surrebuttal and those constitutional rights? Like, how should we conceive of the right to surrebuttal? I know that you're saying in this instance the constitutional concerns pertain, but I'm wondering, is that always true? Sometimes true? How do you conceive of this, if we're just thinking about this from an aspect of, we're going to have to write something that explains our law on surrebuttal a little bit more, because we don't have that much in our jurisprudence currently.
I think one could conceive of it as an evidentiary issue or a constitutional issue. There's probably a lot of overlap. Doctrinally, I think in this case, it went over the edge to a constitutional violation, because it went to the heart of our defense. I mean, our defense was Winfield, and the Anderson testimony seriously undermined our main defense, our Winfield defense. So I think in this instance, it goes into the line of a constitutional violation. Which is, I agree that this court's Gregory is a holding, but I agree that our case law is not as robust as one might hope, but that's why we went to outside sources. The Mississippi court in Edge viewed it as a due process violation. The Second Circuit in Murray, I think, more fairly viewed it as an evidentiary issue. Either way, I think, gets us to where we need to be.
I'm sorry, Mr. Gebbis, I didn't mean to cut off.
Go ahead.
I wanted to ask you if I disagree that this was a right, instance where there's right to surrebuttal as of right, a matter of law, rather than a discretionary call on the part of the trial judge. Would you walk me through the discretionary analysis and why that would have been an error? And if so, again, if I disagree that it was constitutional error, but rather non-constitutional harmless error analysis under Kodiakos, could you walk me through what that would look like in order to reverse convictions here?
Sure. I mean, first of all, the court didn't use any sort of discretionary language here, right? You said it's not a new matter, so you're not entitled to it as a matter of law. But I mean, a judge in this case, I think, recognizing properly that it was a new matter, then it would be a right. But putting that aside, on a discretionary balancing here, Williams's testimony was relevant to our case because it rebutted Anderson, who was a government witness that knocked out or severely undermined our Winfield offense. And on the other side of the ledger, I mean, if you look at 403 balancing, it did not have any unfair prejudicial effect. It wasn't redundant of other testimony. It wouldn't have been time consuming, right? We're talking one witness and some phone records. We're not talking days of and the government never said, oh, if you put that on, we're going to have 7 other witnesses to surrebut your surrebuttal. This was a targeted, brief, proffered case on a discrete but very important issue. So even if the judge had engaged in some sort of balancing here, which the transcript shows she did not, any proper exercise of that balancing would have required admission. And then on your second,
Yeah, on the harmlessness, thank you.
yeah, I mean, so the difference then would be between Chapman and Kodiakis, and for the reasons we've said in our brief, I think we would prevail under either of those, given the importance of this testimony to our case, the largely circumstantial government case, and the points of evidence that pointed away from our client and towards the 2 brothers. For instance, there was the fact that there was someone who was not our client who was seen casing the home in the days prior. There was someone who everyone agreed was not appellant running from the scene of the Porsche fire holding a bucket. There was a white truck consistent with Stefan, his take-home work, driving away from the scene of the van fire. When the brothers were stopped, it was Daryl who had over $7,000 of cash in that vehicle, along with another couple hundred in his sock. No cash on our client. The van was parked in Foggy Bottom, which the government admittedly has no explanation for. If you look at their closing October 22nd at page 66. But lo and behold, it was Stefan who had a job in the Foggy Bottom neighborhood working at the GW dorms. And then the overall sort of implausibility of one person having done this. So given all of those facts pointing away from our client, and again, the circumstantial nature of the government's case, even under it doesn't matter if you apply Chapman or Kodiakis. We think Chapman applies for the reasons we've stated, but under either standard, this court would be required to reverse.
Counsel, I'm not sure you gave the trial court enough credit when you were discussing any theoretical balancing.
Okay.
Let me quote from what she said. More importantly, I don't think that her testimony would rebut testimony that Mr. Anderson provided in the government's rebuttal case, which seems to be a way of stating this is a marginal relevance. And isn't marginal relevance something you factor into the balancing test?
Well, I think 2 things on that. I mean, one, for all the reasons we've stated, I mean, it wasn't equivocal. And to the extent she thought it obviously was a jury question. And again, given the fact that there was no unfair prejudice on the other side. You also, I think, have to read this on the backdrop. The government argued below that some sort of like super relevance applied to surrebuttal. The government lawyer was saying, the question is not whether she has relevant evidence. The question is, are they entitled to surrebuttal? Could they have put on Ms. Williams' testimony during their case? They probably could have. The question now is whether they're entitled to what the prosecutor called the extreme remedy of surrebuttal. So the court is being led down this path that there's some extreme relevance condition to surrebuttal, which simply isn't the case. And again, for the reasons we've stated, her testimony was not equivocal. It strongly suggested that he called on Daryl Texter called that day, but it was the 19th rather than the 13th. And to the extent that that was a close question, it should have gone to the jury, because there was just absolutely nothing on the other side of the scale, other than the government's sort of make weight argument below that there was some heightened surrebuttal standard for the admission of surrebuttal beyond ordinary 401 relevance.
All right, thank you. Unless my colleagues have any further questions, Mr. Gebbis will reserve the remainder of your time for rebuttal. Thank you.
Appreciate it.
Good morning. May it please the court. My name is Nick Coleman. I represent the United States. In this case, the defense was not entitled as a matter of right to present surrebuttal testimony because this was not a new matter introduced during a rebuttal. The trial court also did not abuse its discretion.
Government, Mr. Coleman, can I just jump in and ask if you could just, why did the government feel this was necessary? Specifically, we went through the whole case in chief government. We heard testimony from the defendant. It seems like the government seems to argue both, that this was so critical to rebut what point specifically that the defendant had testified to. And then on the other hand, the government says, well, seems to be saying, they couldn't have been there. Only appellant could have been there. Why did this come in at that moment in surrebuttal as opposed to, not surrebuttal, in rebuttal? What point were you trying to make with this, or specifically rebut? When you say it's not new, that's sort of the underpinning of my question. Why isn't this new?
Okay.
And what was so critical that you had to rebut with this specific testimony?
If there are a couple of questions, I think, in there, so let me just answer them, I think, in order. If the first question is, why did the government present Anderson's testimony when it did, namely in rebuttal? The answer is this. If you look at the government's case in chief, it was predicated on the idea that the home invasion occurs after, or rather around the time just before Amy Savopoulos goes on her walk when she's seen by her friend, Mrs. Pressler, which was at about 3:25 p.m. is when Mrs. Pressler says that she saw Amy Savopoulos walking. And so the government's theory was that the home invasion began after Mrs. Savopoulos left the home to go for her walk, and that the intruder had already overpowered Miss Figueroa and presumably Philip Savopoulos just before, sometime before Mrs. Savopoulos came back. So again, the government's theory in its case in chief was that the crimes began sometime in the mid-afternoon of May 13th. And if you look at the government's, when the defense opened on and announced that to the jury that it would be accusing appellant's brothers, Daryl and Stefan, the government did present some evidence regarding their whereabouts, but it was tailored to the afternoon of May 13th. So in fact, if you look at the cell site evidence that was introduced in the government's case in chief for Daryl, it began at 1:30 p.m. So it did not cover any part of the morning hours of May 13th. That only became the issue of where was Daryl on the morning of May 13th became important when appellant himself testified as to what was going on and claimed that Daryl and presumably his brother, who appellant admitted he never actually saw, but he insisted they were both involved. But he supposedly, the events were set in motion in the early morning hours of May 13th, when supposedly Daryl asks appellant to give him the minivan for the day. And then Daryl supposedly drops off appellant at Ed's house, and that's where appellant is for the rest of the day. So
appellant's argument isn't that the crime starts at 8:30 in the morning after he
No, it's
gets
not.
dropped
I agree.
at Ed's, right? So, I mean, to follow up on the Chief Judge's question, why does the government care so much about where Daryl is in the morning? And if the government thinks that's really important to put into evidence, when Darren has not excuse the use of first names, but just for clarity, if Darren is not making an argument in his defense case that the crime happened in the morning, but the government thinks it's really important to show where Daryl is, why, to the chief's point, isn't there tension there? Why shouldn't Darren be able to respond to where Daryl is in the morning and say, well, he's saying that's where he was in the morning, but it doesn't really matter for the crime. It just shows that he's lying. Like, he's lying about the whole thing. He had the van, and later on in the day, he went and committed this crime. Why shouldn't the defense be able to respond to that?
So again, there's a couple of different points I think I'd like to respond to there. The first of all, why did the government feel, again, getting back to why does the government address the morning hours in its rebuttal case? That's because the defense put them at issue. Now, it had set up some of that. And if you look at the defense closing on October 23rd, they disputed, of course, that Mrs. Pressler actually saw Mrs. Savopoulos in the mid-afternoon. And under their theory of the case, the home invasion could have occurred as early as just after Mrs. Savopoulos' last normal phone call, which was at 11:21 a.m. So the defense basically, by the close of its case, has now set up a scenario under which, first of all, Daryl and Stefan do start the planning or preparation for this crime in the early morning, but that they could have started the execution in the sense of invading the home at 3 or 4 hours earlier than what the government had hypothesized in its case in chief.
Well,
So that's why the
assume-
government is introducing this on rebuttal as opposed to in its own case in chief.
Okay, so under this analysis, the government or the defense has moved the clock back and has said this crime could have happened earlier. But I'm still trying to figure out, the government has said in its case in chief, we think that the crime, the home invasion starts around mid-afternoon. The defense comes back and says, I wasn't there, I wasn't involved, I was at Ed's house starting in the morning, my brother took my van, but has also cross-examined people and elicited evidence that this might have started earlier. Why would the defense in its case affirmatively say, and let me show you where Daryl wasn't? Because it seems to me that's what you're saying they should have done.
So 2 points here. I think, first of all, if the defense is going to put on a third-party perpetrator defense, which it was entitled to do so because it surmounted the Winfield bar of how much evidence has to be put out there. That doesn't necessarily mean, however, that if you put on a Winfield defense in which you're going to accuse a third-party perpetrator, that you now automatically get to have surrebuttal when the government then tries to poke holes in that third-party perpetrator defense, as it's going to on rebuttal. Because after all, that's really the time when the government's going to be doing most of that, because they haven't heard the entire case against the third-party perpetrator. But I think we need to step back here and remember the burden of proof, regardless of whether there is a third-party perpetrator defense put forward, the burden of proof at the trial remains on the government, and that's why it gets rebuttal. The surrebuttal is the exception. It is not the rule in the trial. That's why Mr. Davis is going to be responding here on appeal.
Can I just pause you right there, because you made the point that surrebuttal is the exception and that this is a third-party perpetrator defense, and the defense can't expect to have surrebuttal in every third-party perpetrator case. But arguably, in a case where a defendant puts on a defense, that's probably where surrebuttal is going to happen most often, right? Because you do have this shifting of evidentiary presentations, right? Ordinarily, the government does have the burden of proof. The defense tries to poke holes in that, and the government gets to come back and respond and plug those holes, right? But in a case where a defendant is putting on an affirmative defense, and then the government in rebuttal is trying to put holes in that defense, that seems to be a situation where surrebuttal would actually be quite common and not extraordinary. And I guess it just seems like the government is putting too much weight on kind of a global generalization of like, well, sir, rebuttal is unusual. I mean, it is generally, because generally defendants put the government to their burden of proof and don't put on affirmative cases, right? That is generally in the main how these things go. But when defendants do put on cases, and in particular third-party perpetrator cases, it seems to me that's precisely the instance where we should be more permissive of sir rebuttal, because in cases like this one, the government wants to say, well, the third-party perpetrator, the alleged third-party perpetrator, wasn't anywhere near the scene, was somewhere else earlier in the day. And the defense wants to say, that's hogwash. That's just not true, you know? And I'm struggling to understand why the defendant shouldn't be permitted to do that. If the government thinks that it's so important to put into rebuttal, then why doesn't the defense get to respond to it? Just as in the government's case in chief, if the government puts evidence in, the defense gets to respond to it, you know, either on cross or in a defense case.
So I have a couple of responses to that. I have a specific response in the context of Winfield defenses, which I would like to get to, but I think this is where we need to get back to what is the definition of a new matter. And I'd respectfully submit that it can't just be that because the government thinks something was important enough to put it in its rebuttal case, therefore, by definition, there must be a right, if the defense has something with which to surrebut it, they get to do surrebuttal. The question is whether it is a new matter. And I think I agree with the court, which has noted the fact that you know, there isn't a whole lot of guidance in this court's case law about what is a new matter for surrebuttal purposes. And I think that's largely because surrebuttal is pretty extraordinary. It's not something that is very common in trials. So there isn't a lot of case law on it. But I think if the court here is looking for guidance as to what is a new matter, it could look, I think, to what the Second Circuit, citing the Fifth Circuit, said in Murray. And that's a case, of course, which the defense has relied on heavily, which says surrebuttal is merited where, one, the government's rebuttal testimony raises a new issue which broadens the scope of the government's case, and two, the defense's proffered surrebuttal testimony is not tangential, but capable of discrediting the essence of the government's rebuttal testimony. So there's a two-part test there. I do think that when you're looking at whether something is a new matter, it is not just whether it's something that might be important to the defense, but does it actually expand the government's case? And if you look at, for example, Bynum, Chabi, two cases where this court said that surrebuttal should have been allowed. Now, granted, they did have the hearsay component and the fact that the government was using the statement of a party of opponent. But in both of those cases, the statements of the defendant that the government was purporting to use, in fact, strengthened the government's case directly against the defendant himself. It was not something that related to a separate side issue of maybe someone else did it. And that, I think, brings me to the problem of the Winfield defense.
Sorry, the separate side issue, I mean, that seems to really be minimizing what a Winfield defense is, right? I mean, where there's a Winfield defense, a defendant is taking on a burden of putting on a defense, and they have a constitutional right to do that. That's not a separate side issue. I do want to just ask you though about, and I want to let you carry on, but just to pause on Murray and the language about whether or not it broadens the scope of the government's case. And I'm just wondering if you're putting particular emphasis on that, because right, in Murray, it's all about the cell site evidence that's showing where he is in the area. And then he's trying to say, well, I have different reasons for being in the area.
Correct.
If the government is really relying heavily on broadening the scope of the government's case, I'm not sure how the evidence in Murray actually satisfies that standard. And yet I think in Murray, they said there was a right to surrebuttal, right? I mean, I take your point that it's not as simple as asking, well, does the government think that this evidence is important? We said that in Gregory, right? We said, well, in Gregory, we don't think the government should have been able to put this evidence in. But But where the government does choose to put in evidence that its witness was in a specific location and the defense, and that witness is the third party perpetrator suspect, and the defense thinks that that's all part of a lie, I'm having a hard time understanding why that wouldn't be just practically, unless we're talking about what a new matter is in some really super artificial, contrived, formalistic way. I'm trying to understand why that wouldn't be a new issue to show that the third party perpetrator suspect is lying about where he is the morning of the crime.
All right. So if I could, I'll address Your Honor's question about Murray first, and then I would like to return to the question of why a Winfield defense doesn't expand the right to serve rebuttal.
Great. I'm glad you remember
the-
your train of thought, because I
Right.
do want to hear both.
So with respect to Murray, I think in fact what was true in Murray was the government did not introduce the ample cell site evidence that it had, showing that the defendant was in the area where the drug conspiracy was supposedly based out of, right? It had all this cell site evidence showing his repeated visits to the area, but didn't actually introduce it in its case in chief. When the defendant then took the stand and said, basically, was denied being a part of that. And then the government said, well, we're going to rebut that by showing that he's been there a lot of times. It never confronted him with the cell site evidence. And so he never had an opportunity to explain why he was there on numerous occasions. In other words, that he had friends, et cetera. That was in fact directly inculpatory evidence against the defendant. It showed that he was present multiple times in the area where the drug conspiracy was, that the government did not put on. By the time it put it on, the defendant did not have a chance to try to explain it, to counter it, counter its effect on the jury. That isn't the case here. The government, Anderson's testimony doesn't put appellant anywhere. It doesn't inculpate him in the crime. It doesn't add anything to the weight of the evidence against him. What it does is it may, to whatever degree, and we can argue about that, it may reduce the likelihood that Daryl himself was at the scene of the crime on the morning of. But again, of course, this ignores the fact that this is a two-brother third-party perpetrator defense, which I think is very important to remember. Stefan was a key part of the third-party perpetrator defense because the defense had to explain why a hair with appellant's mitochondrial DNA wasn't just in the garage, but was also in the room with the murder victims. So Stefan could have been at the house starting out the crimes, invading the home, starting the process of tying up the victims, even while Daryl was elsewhere. So again, that gets to whether it was all that important to begin with. But in the context of a Winfield defense generally, I disagree with the idea that the defense has any particular burden of proof. It doesn't. The only purpose of a third-party perpetrator defense is simply to produce just enough reasonable doubt that the defendant did it in the jury's mind, so that hopefully the jury will not convict from the defense's point of view. The defense doesn't have a burden of proof. It doesn't have any particular burden to do anything. The burden of proof remains with the government. It's not even an affirmative defense in the sense that it has to be proved by a preponderance or anything like that. It has to just put just enough of a sliver of a doubt in the jury's mind that they will say, well, if maybe someone else did it, I don't know. I have no idea whether Daryl did it. I have no idea whether Stefan did it, but it's just possible enough that I can't be absolutely sure that appellant did it.
Well,
That's the purpose of that
if I
defense.
could push back and ask just two questions. I mean, one, are you saying that the right to serve rebuttal really only pertains as to inculpatory evidence from the government that actually inculpates the defendant and that doesn't go to a defense raised by the defendant? And two, well, now why don't you answer that question, because I forgot my second question.
All right. I think it does. And if you look at the defenses that were at issue in Bynum and Chabi, I believe, as I recall, certainly in Chabi, it's self-defense. So again, if you refute self-defense, what you're saying is this defendant did it, and not in self-defense. So he's guilty of the crime. I have not seen a case from this court, and I don't really see one, certainly appellant hasn't cited any, where surrebuttal was seen as a matter of right to refute evidence from the government that didn't inculpate the defendant. I haven't seen it.
So
Can I
you think that's a
ask a
rule
follow-up
that,
question on that, if I
Okay.
might object just briefly? We're
Yes.
talking about whether or not the surrebuttal would have inculpated the defendant,
No, whether the rebuttal, I'm sorry, you're
whether
wrong.
the rebuttal inculpated the defendant, and whether the surrebuttal would have squarely refuted or gone to call into question the rebuttal testimony. Why isn't that the case here? The testimony on rebuttal by Anderson was, the video was dropped on the 13th. That's the day that Daryl was there. The surrebuttal proffer testimony was Daryl wasn't there until the 19th. Why doesn't that squarely match up? You seem to be, the trial judge sort of held that surrebuttal proffer testimony wouldn't have squarely met, for lack of a better word, the rebuttal to offer anything relevant, and therefore she exercised her discretion not to allow it, as I understand her rule. You seem to be saying a similar thing, essentially. Can you talk to me about that a little bit?
So the trial judge honed in on two aspects. First of all, just looking at the grand jury testimony, which is already, I understand the court has already discussed this with appellant's counsel. There was the use of the word usually. And if you look at even at the grand jury testimony, Ikea Williams was not, super definitive that she knew for certain that Daryl had in fact texted or called her on this particular day that he visited. Then there was the government proffer that, having spoken to Ikea, at trial, while the trial was going on, she in fact believed, once she was presented with the idea about the haters hate, that was the video. She was there. And it was the day that the haters hate video dropped that Daryl was present. So the jury would have been presented with a somewhat, at best, muddled mess, even from the defense point of view, as to whether Ikea's testimony actually refuted the idea that Daryl was present when haters hate was dropped on May 13th at Anderson's house. So I think, that I think gets to one issue that I do want to make sure that I make clear. It is not the case that if the defense doesn't have an absolute right to present the surrebuttal testimony, that there's no way he can get it in. And therefore, if his, that the proffer that, if he says, look, I've got surrebuttal testimony that's going to refute some of the rebuttal testimony, and we're in the context of a Winfield defense, that, there's no way for him to get it in. The fact is, that's why if there's no right, the trial judge just does still retain discretion to permit the surrebuttal testimony. But I think, again, it can't be something that's tangential, as the Second Circuit and Fifth Circuit point out. And the trial judge does have to retain some discretion to keep the focus of the trial on the relevant question, which is this defendant guilty of the crime? Not, is this a case in which the jury is deciding, did Daryl commit the crime? Daryl was not on trial.
But Daryl was not on trial, but the government called Daryl, right? So the government answered the Winfield's defense by calling the Winfield suspect. And in that situation, it seems like the Winfield suspect's credibility is central, right? Or the government has made it central. The government called and sponsored this individual as a witness. But I did remember my last question, which was that I think you were making a distinction between instances where, you have an affirmative defense, self-defense, where the defendant assumes a burden of proof, right? And we're not talking about that here. We're just talking about a defendant who has a constitutional right to present a defense that encompasses a Winfield defense. And I guess what I'm asking is the government saying that the defense only gets to put in sort of the bare minimum to present their defense, that they don't have a right, as the government does under Old Chief, to kind of present the case how they want to present it? Because that's sort of, it sounds like what the government is saying.
No, Your Honor, we are definitely not saying that. And this is not a case where appellant was only given the opportunity to present a bare minimum of a Winfield defense. His defense went on for some time. I'm not aware that the trial court ever said, you've got to cut it off now. You can't present any, I mean, the defense case goes on for days. There's no evidence here that, the defense, somehow was precluded from presenting evidence in its case in chief that it wanted to. This is a much narrower question as to when is the defense either entitled to, or when would it be an abuse of discretion for the trial court not to permit surrebuttal testimony. And simply because a defendant decides that I'm going to put on a third-party perpetrator defense, I mean, again, this gets back to what the court said in Winfield itself. The trial court has to retain some discretion to make sure this doesn't become a trial within a trial. And permitting surrebuttal as a matter of course would make it a trial within a trial. It would almost be like in civil cases where you have counterclaims and each party is essentially a plaintiff and each party is going to get a case in chief and rebuttal. And that's not what a criminal trial is.
I mean, I think it's the unusual case where the government calls the Winfield defendant as a witness and sponsors that individual. And I guess to your point that the defendant had ample opportunity to present the Winfield case, once the government puts the Winfield suspect on the stand and sponsors this individual and puts their credibility at issue, what was the rush? I mean, why couldn't another half an hour out of this very lengthy trial, why couldn't that time have been taken to allow the defense to put this discrete evidence in that in fact, there might be reason to question Daryl's story about where he was the morning of the crime?
I think that gets to, what was the discretionary authority of the court? And the court could have looked at this testimony and said, again, this is not where it's, look, you don't have a right to do it, but I'm going to balance this testimony, just how important as it is, because yes, the government, one of the Winfield suspects has now been put on by the government in rebuttal. So if, having done that, is the defense certainly had the opportunity to say, this is why we want to put on IKEA, put on her testimony. This is what we expect she would say. The government then proffered, this is in fact what she was going to add if she's put on. And at that point, the trial judge has to retain some discretion to look at this and say, is there a cause now to essentially, prolong the trial, give the last word essentially to the defense case, take the unusual step of doing a surrebuttal case, where the government is still retaining the burden of proof. And that I think is why, again, this isn't a case where the defense should be treated as having just this right in a Winfield case to always present some witnesses to rebut the government's rebuttal in a sense. Is it so significant and that the judge abuses discretion in refusing to permit it? And on these facts, there was no abuse of discretion.
Mr. Coleman, can I follow that up briefly? The government's brief, and it seems to suggest, and to some extent you hint a little bit at it in your argument today, that the defense could have put Ms. Williams on in their case in chief because they knew about her as a government witness and had a sense of what testimony she might offer. How would that have worked, though? I mean, it seems like that might have been confusing to a jury to put on a witness about an issue that hadn't actually been raised yet in their case in chief, essentially to anticipate that the government might call her as a rebuttal witness.
Right. So I think certainly as a matter of, we fully understand why the defense, as a matter of trial tactics, would have preferred to have IKEA testify after Anderson, regardless of when, because she'd be responding to what Anderson was saying. I do think, trial judges do have to permit witnesses to be called out of order all the time just because of witness availability issues. So it's not completely outside the realm of possibility. I think if the government had objected and said, well, why is she be putting on there? The defense could have said, look, we are aware there's this witness Anderson out there. We don't know if the government's going to call IKEA and, we need to put this on. And at that point, the trial judge could have made a call, and maybe the parties would have worked something out. But I think in general, the question of whether the defense should have to put it on earlier as opposed to later, I think is really more of part of the question of the discretionary balancing of the court as to whether to permit rebuttal. It doesn't really have to do per se with whether there's a right, which I think is one of the mistakes that appellant is making here, to argue that we should define something as a new matter solely as whether or not the defense would have had a reason to put it on earlier. And I don't think that properly captures what's a new matter that gives them a right to put on rebuttal testimony. It may go into the mix when when there is no right, but the trial court is making a discretionary balancing call. But again, that isn't the question of whether or not IKEA could have or should have or easily, in an easily understandable manner could have been put on in the case in chief. I think is an interesting one, but it is not one that defines whether there was a right to put on rebuttal testimony. I would like to address briefly the question of harmlessness.
But before you go
sorry.
there, I'm so sorry. Could you just succinctly tell me how you define new then for a new matter?
I do think
what would the
that
government's definition
Right.
be of what is?
So obviously this court, I think, the best guidance that this court has given was in Gregory to say it was a new material issue
But that
introduced,
doesn't
which again
define what's
isn't
new.
right. No,
What is the government's understanding of what is
Right.
new?
and I think I do think that the best definition has been given by the Fifth and Second Circuits in Murray, that it's got to be, in order to have a right to provide rebuttal testimony, the rebuttal testimony must have expanded the scope of the government's case. In other words, it has to be evidence that really inculpates the defendant per se and doesn't relate to an issue that isn't about what is directly inculpatory of appellant. The fact that appellant has taken upon himself to point the finger at someone else doesn't give him then a right to put on whatever evidence he thinks will strengthen that pointing a finger at someone else. It's when the rebuttal testimony points directly back at appellant that it is more likely that he's going to have a right to put on rebuttal testimony, because he needs the chance to respond to evidence that directly inculpates him. But when he's saying, I've got evidence that might inculpate someone else that he chose not to put on in this case in chief, again, that's when I think the court retains some discretion as to whether it comes in or not, and has to look at the strength of this evidence, how important it is, how tangential it is in making the call as to whether, the trial should be held up for that purpose.
And one last question, I swear. Do you have authority to support this inculpating theory? Because Murray isn't it, right? I mean, Murray, there's no affirmative, there's no defense, there's no Winfield defense, there's no self-defense. Do you have a case where the defendant is trying to present a defense that the government has responded to in rebuttal, where a rebuttal has been denied, and the court says, well, look, this isn't expanding the scope of the government's case. This isn't inculpating the defendant. So no, you don't get rebuttal. Do you have authority for that?
I don't, Your Honor. I don't have authority on the other side either that says that there is a right, or at least I'm not aware of any, that says that there is a right to present rebuttal testimony to respond to evidence that doesn't inculpate the defendant. And certainly not, I'm not aware of anything in the context of a Winfield defense. I mean, again, obviously Winfield is a direct creation of this court, but obviously a third-party perpetrator defense exists in other jurisdictions. I'm not aware, I don't know for sure that there isn't such a case out there. I don't believe the defense has cited any, and certainly this court has not so held, but then again, this court hasn't addressed rebuttal in the context of a Winfield defense. I realize my time is up, but I did want to touch on the issue of harmlessness because I think it's important. We do believe that even if this court were to find error, whether either an error in abuse of discretion or an error that, depriving as a matter of right rebuttal, this nevertheless, any such error was harmless under any standard of review. And that's because at the end of the day, the question of whether IKEA could have potentially undermined the idea that Daryl was at Anderson's house during the late morning hours of May 13th. we don't think it even was really all that central to appellant's Winfield defense, again, because he was presenting a two-person Winfield defense. But in the context of the entire trial, given what we do believe was overwhelming evidence against appellant, this is not the issue that would have caused the jury to question that evidence against appellant. Contrary, I think, to what appellant's counsel has said here today, we think the evidence against appellant simply was overwhelming. His DNA, not that of his brother's, was what was found on the pizza that was ordered during the night when the victims were held captive. That pizza is upstairs. Its hairs matching his mitochondrial DNA are found in the garage. He essentially admits in his own testimony that was his inside the hard hat, but that additional hair is found next to the victims. He had to inculpate Stefan, not Daryl, as being the source of that hair. It's appellant's DNA on the vest that's found in the burned Porsche, not Daryl, not Stefan. It's appellant's DNA that's in there. He is the one seen by the restaurant workers walking back and forth before the Porsche is burned. He's the one seen entering the house not long before it is set fire by the employees at the Australian embassy. The 24th and K is typed into his phone after the delivery of the money. And he's the one who then enlists a tow truck driver to go back and tow his fully functional minivan from DC back into Maryland to a location fairly near where the Porsche is burned. He is the one who calls Ailing, and as he himself admits, asks for Ailing's help in burning the minivan about an hour before the minivan is burned. The evidence, and he is the one who is seen with, lots of $100 bills during the first few days after the crimes, and who was telling stories about how he won it in the lottery, etc. He's the one who he later admits had the phones that he believes, in fact, did come from the house. And it's not Daryl or Stefan that there's any evidence had that in their possession. Obviously, we go through more of that evidence in our brief, but we think that evidence is what would have, that is the evidence that led to appellant's conviction. It is not any dispute over Daryl's exact whereabouts during a couple of hours during the 2 days when this crime was committed. And in light of that, both the nature of the Winfield defense that appellant put on, but also the powerful nature of the evidence against appellant. Any possible error was harmless regardless of whether it was done under Chapman or Kodiakos. If there are no further questions from the court, we respectfully submit that the judgment of the Superior Court should be affirmed. Thank you.
Great, thank you. Mr. Gebbis, we've reserved a few minutes for rebuttal.
Yeah, very briefly, because government counsel addressed it last. As to harm, the parties have set forth their arguments, but for the first time here, I'm hearing the notion that where Daryl was that morning didn't matter because Stefan could have been doing the crime back in DC. That's just not at all how the government tried the case. The government did get an aiding and abetting theory. The government described that for the jury as a cushion if the juror had any doubts as to whether defendant did it alone. However, in presenting its aiding and abetting cushion, it said, and you know what we don't have to do, and you're going to hear about it in a minute, aiding and abetting. We don't have to prove to you whether or not Darren had any help committing these crimes. But the one thing you do know when you go on the back is that Jordan Wallace, Daryl Wint, Stephen Wint didn't help him. So yes, they got an aiding and abetting instruction, but their theory, even as to aiding and abetting, was it was not Daryl, it was not Stefan. So the government's argument now that, well, it doesn't really matter what Daryl was doing because Stefan could have been doing the bad stuff back in the district is made up. Of whole cloth here at oral argument, as is going to the merits. This idea of directly inculpatory versus something else, that's just not in the case law, and it doesn't. On the other side of the ledger, again, of course, is our right to present a defense and confront the government witnesses. That's what's on the other side of the ledger. So this notion of directly inculpatory just doesn't find any place in the case law, and even in Murray and in the Edge case that we cite in Murray that the government relies on, at least generally, illustrate that newness is about new facts, not some new general topic. It's new facts. And that's what was at issue both in Murray and Edge and in this case, and why this court should follow the lead of those cases, abide by its holding in Gregory, and find that the Anderson alibi evidence was a new matter such that we were allowed a brief rebuttal to rebut it. And if there are no other questions, we'd ask the court to reverse.
All right, thank you. We'd like to thank both counsel for your arguments and your briefs today. And this matter is submitted and we'll take it under advisement. You're free to exit our virtual. Thank you both.
Good day, everyone.
All right, good morning, counsel. This is our second matter before the court today for argument. In Ray Lawrence O'Neill, our parties ready to proceed?
Yes, Your Honor, we are. Mr. O'Neill is.
Yes, disciplinary counsel is too, sorry.
Okay, shall we begin?
Certainly. Who proceeds first?
I'm sorry, I didn't hear. I'm
All
in
right.
trouble.
Who proceeds first?
Mr. O'Neill, I believe that you do, and if you'd like to reserve some time for rebuttal, you may do.
All right, thank you. Okay. I have 15 minutes, is that correct?
That's correct.
Thank you. All right. Good morning, Your Honor. Thank you for this hearing. I wanted to, this is a very simple matter. It is, I think we can deal with it in a very straightforward manner. The case brought by disciplinary counsel in the District of Columbia against me is without foundation in either the bar rules or in the jurisdiction of the District of Columbia Bar. The matter pertains to a non-legal matter, a issue between third parties where I was not acting as an attorney. In fact, I was acting as a friend of a client of mine on advising his brother in a matter. I was not retained by the brother. I did not have any legal role with the brother. I was not admitted in the jurisdiction where this took place, which was in Ireland. I repeatedly represented to both brothers that I was not admitted in Ireland and could not provide any legal advice pertaining to the matters in front of them. My sole advice was negotiating advice on how to negotiate on the matter.
Mr. O'Neill,
Yeah.
you're reciting the facts as you understand them. It seems to be following your briefing.
Yes.
But the facts as the hearing committee found them and as accepted by the board were quite different. And we are required to accept those findings unless they're unsupported by substantial record evidence. And I did not see in your brief that you had acknowledged that standard of review, nor did I see any argument in your brief that the hearing committee's findings as accepted by the board were not supported by substantial evidence. I just saw your account of the facts that had no citations to the record.
Well, unfortunately, this case is unique in that it's an extrajudicial application of the DC Bar rules to a
Okay, that's flipping to a legal argument, but I just want to focus on the facts right now. Do you
Okay.
you agree that we are bound by the facts as found by the hearing committee and adopted by the board in the absence of any argument in your brief that those factual findings are unsupported by the record?
I believe those facts are unsupported by the record, and
Okay, but you did not make that argument in your brief. Is that correct? Or is there somewhere that you would like to point me in your brief, other than your account of facts that doesn't align with the facts as found by the hearing committee and adopted by the board?
dispute of those facts. I believe those facts are not supported by the record.
Okay. So you were about to talk about the extraterritorial application of the rules. Your brief is citation free. So can you tell me why you think that the DC rules do not apply to you wherever you are on the globe?
I didn't say that in my brief. The DC rules apply to attorneys practicing law. They seem to have application in other states, other jurisdictions where parties are.
So where you were charged and found to have violated a dozen different rules. That's an estimate. I didn't actually stop and count. And I grant you that Rule 1.5 and 1.15 and 1.16 by their plain text appear to be talking about lawyers acting in the scope of representation of their clients. Let's set those aside for a second. The other rules do not seem to be by their plain text so limited. They seem to apply to bar members. Full stop. So what is the basis of your argument that rules like 8.4b or 8.4c do not apply to non-legal activity?
That is not, I'm not making, clearly the bar has the right.
I'm sorry, I missed what you said. You're not making that argument.
I'm not making that argument. I'm focusing on 1.5 and 1.15 primarily because those are the most serious allegations against me that I have misaccounted for, misappropriated client funds in the course of representation.
You think that the 1.15a violation is more serious than the violation, the assertion that you have committed criminal acts?
I dispute the criminal acts. I did not
I
commit.
understand that. Okay, so you are conceding then that your argument about the rules applying to only conduct taken in the course of representing a client is only limited to 1.5, 1.15, and 1.16.
Of the bar rules that relate to representation of clients.
Okay, all right. And there was a finding of fact that you were acting in the course of representing Mr. Adriano Fusco. So where does that leave us?
It leaves that there is no representation in the record that I was in fact representing Mr. Fusco. There is no retainer agreement. There is no contract. There is no agreement between Mr. Fusco and myself.
I don't think that the board said that there was. I think they looked at the circumstantial evidence and decided that all of this indicated that you were representing Mr. Fusco. I mean, things like the fact that you extended the offer for Mr. Fusco to purchase, I'm forgetting the woman's name, to purchase her share in the company made on your letterhead. You said that the offer was governed by Irish law. You charged, 4,000 some euros in legal fees. All of this information led the the hearing committee and then the board in turn to determine that you were acting in a capacity, plus Mr. Fusco's testimony that that's what he understood you to be doing, led them to conclude, make a factual finding that you were acting as his lawyer.
I believe that that finding is incorrect and not supported by the facts. The legal fees were nowhere recorded. They were collected or requested of Mr. Fusco after the fact, after he had been paid by the other parties. They were not agreed. There is no legal representation here of any kind. And as to the criminal acts, there were no criminal acts. There were no criminal charges. There were no criminal acts.
There don't have to be.
There was no.
Do you have any authority to say that you have to have been convicted of a crime to have found in violation of 8.4B?
You certainly have to be charged with a crime.
What's your authority for that?
Disciplinary counsel. Well, I have no basis for that. I don't think anyone has ever been accused of violating the bar rules for criminal acts, having not been charged or accused or convicted of a crime. I mean, out of whole cloth, they can argue that this is a crime. That is obviously ridiculous. There was no crime charged.
Why would that be ridiculous? I mean, the point is that to be convicted of a crime, you have to be found guilty beyond a reasonable doubt. And once you're convicted of a crime, you may be deprived of your liberty, right?
Right.
Your liberty is not at issue here, it's your bar license. And a disciplinary body such as this court could say, we see evidence not beyond a reasonable doubt, but by clear and convincing evidence that you have committed a crime, and we are going to deprive you of your bar license. Why is there a problem with that? And do you have any authority to support your assertion that that would be unfair?
I don't think I need authority to support that. That would be unfair. You are depriving me of a livelihood, of a means to make a living on the basis of conjecture. There were never any.
If we say that the evidence supports the finding by clear and convincing evidence, and we hold ourselves to that standard, it wouldn't be conjecture. And frankly, if we're asking for authority, then the response that you don't need the authority isn't terribly helpful to you.
Well, you're absolutely right. I apologize for that statement. You're
Mr.
right.
O'Neill, if I could ask a question.
Yes.
You indicated and before the hearing committee, and I think you still maintain that in your briefs, that you made a payment or you still intend to pay Mr. Fusco back.
Yes.
Can you tell me whether you've done that?
Yes, I have paid more than the amount of money that I owe to Mr. Fusco into the account of my solicitor, Mr. Martin Moran. I made that payment 2 months ago to settle with Mr. Fusco. There were a number of, I basically wanted a quick claim from Mr. Fusco. And I talked to Martin this morning and he expects to have that by the end of this week. The process has been, Mr. Fusco has been requesting substantially more money than the amount of money that.
So how much do you pay Mr. Fusco, and how much do you owe him?
Mr. Fusco, as far as I know, has not received any funds from Mr. Moran yet, but I have given Mr. Moran into his trust account in Dublin, 220,000 euros.
Mr. O'Neill,
So the bar disciplinary council and the hearing committee, do they have any documentation of payment that you say you do for satisfy the amount owed to Mr. Fusco?
I can provide that documentation of the transfers to Mr. Moran, and I can provide a letter from Mr. Moran acknowledging the receipt of those funds and his discussions with Mr. Fusco and Mr. Fusco's solicitor.
Not been provided prior to me asking you at the hearing today.
It has not been provided. I was hoping that Mr.
And
Moran.
when was it done? When did you say?
On the I don't know the exact date, but it was before, so it was the 7th of February.
Mr. O'Neill,
Yes,
you will agree that there have been times before in this 6-year-long saga that you have made representations to tribunals that, similar to this one, that the check is in the mail, the money has been paid. And then you have admitted that those statements were untrue. Correct?
correct.
And it would be unfortunate if you were making another representation to this court that were untrue.
I would not
But
make.
in any event, the
would not.
representation that you are making currently is not part of the record. Are you saying that we cannot judge whether or not you should be disbarred based on the 6 years of evidence in the case to date? That we have to hold the record open to allow you to repay the money now?
The money has been repaid to my solicitor.
I understand that you are making that representation now.
Yes,
My question is more to the issue of mens rea, which you have said is not proved because you always intended to pay the money back. And now you are making a representation today to this court that it has been paid back, or it has been, it is in transit because it is with your counsel and will be paid to Mr. Adriano Fusco forthwith, one imagines. And my question is, are we obligated to hold this case in abeyance because you say now you have paid? Or can we take a look at the record evidence over the past 6 years and say, that is evidence of your intent when you took the money, and whatever you are doing now is legally irrelevant?
no, I believe that you really should, in fairness, hold the case in abeyance for the, I can give you, I've sent to the.
Do you
court-
have any authority for that?
And I do not, I'm sorry.
All right. Mr. O'Neill, we'll allow you to reserve a few minutes for rebuttal, and we'll hear from disciplinary counsel.
May it please the court, Julia Porter on behalf of the Office of Disciplinary Counsel. The hearing committee and the board unanimously found that there was more than substantial evidence indicating that Mr. O'Neill was representing Mr. Fusco and doing so as a lawyer. And that he engaged in intentional misappropriation when he took 174,000 euros belonging to Mr. Fusco without his knowledge or his consent. Separate and apart from the intentional misappropriation, which alone justifies disbarment, the hearing committee and the board unanimously found that Mr. O'Neill engaged in criminal conduct, theft, and fraud, as well as numerous acts of dishonesty directed at his client, the solicitor for his client, the Irish court, and the disciplinary council, and the disciplinary system. And I'd note that Mr. O'Neill's statement today about his
Can I interrupt just briefly to ask a question? What's the basis of the findings by the hearing committee to support the flagrant dishonesty? Is it just the credibility determinations based on Mr. O'Neill's testimony, or were there other facts considered by the hearing committee?
They were numerous, Your Honor. First was the dishonesty directed at his client. He made many false representations, some of which he tried to corroborate with fabricated documents, which he sent his client. He did the same thing with respect to the solicitor who intervened.
The documents were part of the record before the hearing committee.
I'm sorry, I didn't hear, Your Honor.
I understand his testimony and some of the credibility determinations made by the hearing committee, but my question is targeted at what other evidence was the basis of the hearing committee's findings about flagrant dishonesty. Did the hearing committee have those documents that it determined were fabricated? Were
Yes.
there types of evidence in addition to those documents, other than a credibility determination about Mr. O'Neill's testimony?
I think, as I understand both the hearing committees and the board's decision, the flagrant dishonesty was the underlying conduct and the evidence that was presented about that conduct at the hearing. Mr. O'Neill's false representations and false testimony at the hearing were, I guess, aggravating factors, but they didn't factor into the flagrant dishonesty that the hearing committee and board found. And all the, I guess, falsified and fabricated documents, including the affidavit, that Mr. O'Neill presented to the Irish court, the false financial records, the false statements, including in writing both to his client, the solicitor, and the Irish court, as well as disciplinary counsel, were all part of the record before the hearing committee. And it's on that basis that the hearing committee found that there was flagrant dishonesty. It was pervasive. It continued for years. It included the fabrication and presenting of false evidence, including before the Irish court. And again, the evidence to support that is ample. And I'd note that the dishonesty continued even at the board level, where Mr. O'Neill made a similar representation to the one he made today, that he had paid Mr. Fusco shortly before the board argument, which is a knowing false statement. And I think that even if it were true, which I doubt, it provides no defense to any of the charges that the hearing committee and board found, nor does it provide any basis not to disbar Mr. O'Neill for his intentional misappropriation, flagrant dishonesty, and criminal conduct.
Ms. Porter, let me ask you, assuming before we issue our opinion, we get absolute proof that Mr. O'Neill has paid the money to Mr. Fusco, and disciplinary counsel is satisfied with that proof, would that in some way serve as mitigation?
Well, it certainly would serve as mitigation if Mr. O'Neill was ever to seek reinstatement. But as I indicated, it provides no defense to any of the charges, including his criminal conduct. And it should not change, and the court should not hold, delay its ruling in this case, because disbarment is the only appropriate sanction given the nature and extent of Mr. O'Neill's conduct. I mean, the only thing it would change is that the court wouldn't be required to put in a restitution with interest provision in its disbarment order, but that is the only thing that it would change.
Which cases come closest, in your view, to supporting the sanction of disbarment here? I know we have In re Johnson Ford, where there were, where we determined that disbarment was appropriate because we had about 5 separate examples of misappropriation. We have In re Edwards. Which cases are disciplinary counsel relying on most to inform us about the appropriateness of the proposed sanction?
Sure. For the intentional misappropriation, In re Adams, the court's en banc decision that said anything more than negligent misappropriation, and here it was intentional and it was theft. And separate and apart from the intentional misappropriation, disbarment would be warranted for the, I guess, flagrant dishonesty and criminal conduct. I'd cite to you Goff and Gill and Slattery, all cases where there was no finding of a 1.15 misappropriation, but solely based on the lawyer's dishonesty and criminal conduct. And in Goff, there wasn't even the criminal conduct component. There was just the dishonesty and presenting false evidence to the court.
There was the flagrant dishonesty, and how Goff, I know, has some language distinguishing what we viewed as dishonesty versus flagrant dishonesty. Can you just elaborate a little bit on why the instances alleged here amount to flagrant dishonesty?
Sure. I think what the court is focused on in other cases where it's found flagrant dishonesty or disbarred a lawyer for dishonest conduct is the repeated and protracted nature of the dishonesty. And as I stated before here, there was dishonesty directed not only towards the client, but the client's solicitor, the Irish court, and the disciplinary system. Also, I guess, kind of it's intentional, repeated, and I guess a lack of acknowledgement or remorse where the disciplinary system has no, I guess, comfort, or doesn't have a sense of comfort that this isn't going to recur. But I think it's more the repeated and the pervasive nature of the dishonesty that has convinced the court in other dishonesty cases that it is flagrant and warrants disbarment. And that is truly the case here, given the findings of the hearing committee, which the board adopted.
Is your view that disbarment for misappropriation is automatically required under Adams, but that there's some discretion with respect to whether disbarment is automatic on the flagrant dishonesty allegations?
Well, in Adams, I mean, the court did provide for exceptional circumstances where they wouldn't order disbarment even if it was more than negligent. In the flagrant dishonesty cases, I guess the ones I'm familiar with, the court did disbar the attorney. I know in one of the cases, Baber, B-A-B-E-R, there was an allegation that this was flagrant dishonesty, and without, I guess, just saying or ruling that it was flagrant dishonesty, the court nevertheless disbarred the attorney because, again, the dishonesty was repeated and protracted, and directed both at the client and the court system. So I don't know of any cases where the court has found flagrant dishonesty where there wasn't a ruling of disbarment, but the court has never said it has to be disbarment or that disbarment automatically flows from that. Although
if we found persuasive Mr. O'Neill's argument that he wasn't practicing law and acting as a lawyer, and therefore the 1 point violations were not applicable to him, and I'm not sure I'm persuaded by that argument. But if we did determine that, is there a sufficient basis for disbarment solely under the flagrant dishonesty counts here, if
Sure.
we did not include the misappropriation counts?
Certainly. In Ray Gill would be a case where there wasn't a finding by the court that the attorney was acting in his capacity as attorney, but nevertheless disbarred him. And there, I guess the theft of funds from the victim was temporary in the sense that Gill, when he was reported to disciplinary counsel, admitted what he had done and repaid the victim. And there was no finding that the Gill had intended to permanently deprive the victim of his funds. And there wasn't any finding of flagrant dishonesty. And in that case, where the facts are far less egregious in this case, the court disbarred the lawyer. And there's a number of other cases, Goff, which we've already talked about, Slattery, other cases where there was no intentional misappropriation and the court nevertheless disbarred the lawyer for taking funds, stealing funds from somebody else, and dishonesty.
I have one last question for you, Ms. Porter. Mr. O'Neill argued that because there were no criminal charges brought against him or no criminal convictions, that the 8-point rule, the violations under Rule 8 are not really applicable. Can you just describe briefly the legal standard that the hearing committee applies when they're trying to determine whether or not there's been criminal conduct for which the disciplinary system can consider taking some disciplinary action? Standard of review and your legal standard there.
Certainly. And I point out that, this court has held in numerous cases, including the In Re Gill case that we just discussed, that you don't need to be convicted or even charged of criminal conduct. And I think Judge Easterly referred to kind of the 8.4b violations, which is they have to violate the elements of a criminal statute. In this case, we argued that Mr. O'Neill's conduct violated both the New York and the Irish theft statutes, which this is where the money was and where he took it. And we have the burden of proving that it satisfied each element of the criminal theft statute by clear and convincing evidence, which the hearing committee and board found. So that the proof in this case was more than enough to show that Mr. O'Neill violated 8.4B, not just by stealing Mr. Fusco's money, but also engaging in what the hearing committee and the board found was also constituted wire fraud.
Is it stealing if he's repaid it?
Well, under the DC rules and, well, excuse me, under the Irish rules and under the New York statute, which you cited, given the takings and how long Mr. O'Neill has kept the funds, yes, it is theft under both the New York and the Irish. And in Gill, which I mentioned before, the court never found that there was an intent to permanently deprive the victim of the funds, yet the court said, under DC rules, which apply to Mr. Gill's case, a temporary unauthorized use could constitute theft. Here, it's been more than temporary, and I guess, infer Mr. O'Neill's intent by the circumstantial evidence, including his actions. And clearly, as a hearing committee and the board found, he engaged in theft under the rules or under the laws of both Ireland and New York when he took Mr. Intentionally took Mr. Fusco's funds, knowing that he had no right to do so, and to date has failed to pay them back.
Are there any other questions?
No.
Ms. Porter?
In which case, I'd ask that the court affirm or adopt the report and recommendation of the board and disbar Mr. O'Neill and require restitution with interest. Thank you.
I realize we may have proceeded in a procedurally quirky way this morning. I think I was thrown off because your nameplate, Ms. Porter, says counsel for appellee. Mr. O'Neill says counsel for respondent. And so we had him go first, where typically disciplinary counsel would have presented their argument initially. But I think we have muddled through, and we will give Mr. O'Neill the couple minutes of rebuttal time that we had indicated he would be entitled to.
And we point out a couple of things. First off, in terms of the dishonesty, that is the allegation, the claims made that the funds had been paid were made in good faith at the time. I had thought that they were being paid by third parties on my behalf. They were not. I shouldn't have made the statements until I knew they had been, but that's the way it was. There were third parties who promised to pay them and did not pay them, parties who owed me the funds and did not repay them. In terms of criminal conduct, this issue was in fact taken by Mr. Fusco to the Irish police, and who argued that because Mr. Fusco had given me the funds, and it was not in a fiduciary capacity, it was merely he was a third party. He gave me the funds specifically, in fact, because he was attempting to keep the funds out of the hands of the Irish tax authorities. As a later
Mr. O'Neill, once again, this is your version of the facts.
You're right.
That were not credited. And in particular, I didn't see any information, I believe, that you represented in your brief, that the Irish authorities didn't perceive this to be a crime, but I didn't see any evidence, even any testimony from you, that that was the case. The evidence at the hearing was that the Irish authorities declined to prosecute because this was below a certain monetary level. Do you have somewhere to point me in the record to support this assertion that you're making today, that the Irish authorities did not perceive this to be a crime because the money was given to you voluntarily by Mr. Fusco?
It's not in the record.
Thank you.
That is in fact the truth. Fusco in the record stated when
we're an appellate court and we are bound by the record before us.
Yes, understand. There was no criminal act undertaken here, and there was no dishonesty throughout, except for the allegations of repayment, which I regret and aren't true. This time, the funds have been sent, at least to my solicitor, and he is negotiating with Mr. Fusco to get a quick claim to pay him. And that is my understanding as of discussions with.
So your representation is that you will not pay Mr. Fusco until he gives you a quitclaim? Is that your current representation?
I want Mr. Fusco to release any claims against me for the funds once he has been paid.
Notwithstanding that there's an Irish court judgment against you saying that you must repay these funds.
If we have to go to the Irish court to do it, we will go to the Irish court.
The Irish court's judgment is already pre-existing and is now many years old.
It is expired, unfortunately. So we have to go back to the Irish court and ask the judge to receive the funds in payment if he will not agree.
Your representation to us is that currently there is no active judgment by the Irish court requiring you to pay this money back? That expires at some point?
As my understanding from discussions with Mr. Moran, who was my solicitor. I don't practice law in Ireland and I don't know Irish law very well, but Mr. Moran has informed.
That's an interesting way of money judgments working.
Well,
that they would expire at a certain period in time,
Mr. Moran
whether or not they had been repaid.
It is the way this judgment was brought, apparently, by Mr. Fusco. He brought it in a form to hold me in contempt for non-payment. That expires with the term of the court, the way it was brought. So he would have to bring a different judgment. Hopefully the resolution, I am shocked that it has taken this long for the parties to come to an agreement. All I want is an agreement that once Mr. Fusco is paid, whatever sum it is agreed, the amount owed plus interest, that Mr. Fusco is not going to come against me with another claim of funds and drag me into an Irish court again for some specious claim. I think that is prudent, and I have asked Mr. Moran to expedite that process, and he is attempting to do so.
All right, well, thank the parties for your appearances today, and this matter is taken under advisement. Thank you. And you're free to exit our virtual courtroom at this time. All right, good afternoon. Our third and final matter for oral argument today is Illuminate Media Group LLC versus District of Columbia and CLPF CC Pavilion et al. Versus District of Columbia. Counsel, are you ready to proceed?
Yes, Your Honor. Thank you. Good morning. Good morning, Chief Judge and Your Honors, and may it please this court. My name is John Soretta of Day Pitney for Appellant Illuminate Media Group. I would like to reserve 3 minutes for rebuttal with the court's permission. This is a case about whether the mayor and her agent can use emergency powers to eliminate the legislature's role in reviewing and approving changes to the law. We believe that the mayor's agent cannot do so under Section 61409 of the DC Code, and in the alternative under the independent requirements of the DC Administrative Procedure Act. But I did want to start off.
Mr. Soretta, can I jump in with a question for you? Under 61409, there is a reference to Chapter 505, Chapter 5, which includes Rule 2-505 about emergency authority to promulgate emergency legislation. How do you reconcile that with your statement just a moment ago that there was no such authority? Seems to be, if you read those two together, that perhaps there could be a situation where emergency legislation could go forward, be enacted, which would not preclude permanent legislation from also proceeding along the 45-day review period suggested in 1409.
I think that's incorrect, Your Honor, under the text of Section 61409 and the structure. And if I could just lay it out, the second sentence, as you note, does say that the mayor may issue proposed rules under the DC Administrative Procedure Act. So it does have that reference, and we agree that's a reference to the DC Administrative Procedure Act, which includes 2505 and 2505C. But 61409 remains.
Which are the legislative procedure provisions of 505 of Chapter 5, Title 5.
Correct. It references the entire title. But 61409 remains the organic and enabling statute that provides the source of the authority. And it is necessary to keep reading and to read 61409 in its entirety. So it refers to proposed rules under the DC APA. And then it goes on and it says those proposed rules must be submitted to the council for a period of 45 days for review. If the proposed rules, again, using the word proposed rules, are then subject to that 45-day period.
Right. But proposed rules are subject typically to a 45-day review period, but not emergency rules. And then that's sort of the heart of my question here. I agree with everything you said, but I just don't see how that negates that there could be these essentially parallel processes. One that immediately allows for the promulgation of emergency rules that would take effect immediately if an emergency has properly been established. And then, that emergency legislation or rule could then be eventually superseded by the permanent official rule that is moving along at a slower, more methodical, deliberative pace.
Two responses to that, Your Honor. First, it is only the proposed rules that are the incorporation of the DC APA, such as it is referring only to proposed rules. And then I think that argument would be more persuasive were it not for the last sentence of the statute. So after saying go through the period, have the 45-day reviews, if it is not voted up or down within those 45 days, it shall be deemed approved. There is a final sentence there, not present in the other statutes that have very similar language.
And the 1409. You're talking about the last sentence in 1409?
Yes, there's a last sentence in 1409 not present in hardly any other statute with similar wording. And that is the one that says the rule shall not take effect until approved or deemed approved by the council. So even with that reference to the DC APA and all of its provisions, the remaining sentences of the statute, and really it's that last one that I think clinches it, say that the rule shall not take effect until approved or deemed approved by the council.
To make sure I understand your point, I think you're saying the word proposed does not appear in that last sentence. So that last sentence speaks globally of rules of all kinds, and they shall not take effect sooner than 45 days.
Indeed, it does not use the word proposed in that last sentence. I think even without that sentence, there would be an argument. I think it would be not as strong an argument as there is with that sentence that refers to rules, just rules. And the only rules that have been discussed in the previous sentences are the ones described that would be proposed pursuant to the DC APA.
This might be a good time to ask you whether you have a response to the order we issued on Monday, I believe. There's another statute out there that might speak to this topic. What do you make of it?
Yes, and I did want to address that, and I appreciate the court for alerting us to that you had questions about it. So yes, 1303.21 does apply to this situation. It speaks by its terms to signs on, quote, private property within public view within the district, and that is what this case is about. It also requires affirmative council approval to make law in this area, and no such approval was obtained here. Now, of course, we haven't pressed that it's exclusive. We didn't press that below. We haven't pressed that here, but the court having noticed it sua sponte, we feel pretty pretty strong on 61409, which was the only authority cited as the basis for the emergency rule, that the emergency rule is invalid under 61409. But the court, having noticed it and asked us about it, our position is that the best reading is that it is exclusive. But again, not something we've pressed. I am happy to lay that out briefly since the court is interested in it. In our view, so 1303.21 was substantially amended in 2013. At the same time, there were also some amendments to some of the provisions around 61409, 61403, that was also further amended in 2016. And we think that the totality of those provisions basically required DC to proceed under 1303.21. That would be, in our view, the better reading of the statute. Now, I recognize that this would be an issue on which supplemental briefing might be helpful if the court wanted to address it. But it's really DC Code 61403, which sets the scope of the construction codes process. And that was amended in 2013 and 2016, as I said. There's a subsection B of 61403 that says that the construction codes can control the construction, reconstruction, maintenance, a lot of other words, of interior signs or other items as specified in the construction code. So we think that that change in language combined with 1303.21, the best reading of it, mind you that we didn't press it below, but the best reading of it would be that you had to proceed under 1303.21 for exterior signs, and the district has described these as exterior signs a number of times in its brief before this court.
Perhaps we will ask you for supplemental briefing. We'll let you know about that later. But from what I've seen, this whole area is a mess. 1303.21 was part of legislation that was intended to take signs out of the construction code. And there are various provisions that were not to go into effect until comprehensive rules, regulations were adopted, and that never happened. So
yes, that's absolutely right. That never happened. But then in 2016, there was a further amendment to the provision I've just been citing, 61403, that did add this interior language, notwithstanding that trigger from the 2013 Act had not gone into effect. I will, though, unless the court has further questions on it, recognizing it's not something on which you have briefs, press ahead.
Please do.
So 61409, we think, is quite clear. The emergency rulemaking provisions, we don't think provide any independent authority, certainly. And I think that has to be true. One reason I think it has to be true, 2505C speaks generally of the mayor or an independent agency having an ability to issue emergency rules that may go into effect immediately. And if that were some independent authority, which has sometimes been suggested, well, then it would be unmoored from any organic or enabling statute. But I don't think anyone would claim that, say, the Washington Metropolitan Airport Authority has 2505C authority to issue emergency rules in this area, even though independent agencies are mentioned in the statute. So it has to be 61409, and that the totality of 61409, as I've stated, especially that last sentence, provides no doubt. We think it's clear on its face that those rules could not go into effect until the approval or the deeming of approval by the council.
Right, but doesn't Rule 303 also have the same language at the end? That the rule shall not take effect until approved by council. That same language is in 303, as you referenced in 1409.
Yes, it is. It is. I am aware of three. So there are a lot of statutes, as I'm sure this court knows, I'm sure it sees them, that have similar authorizations of mayoral or agency rulemaking authority. I'm aware of only three that have language like that last sentence. One, 303.21, which actually they're deemed disapproved under 303.21 if they're not affirmatively approved, but it does have that same sentence. That's right. our statute here, 61409, and a statute that the district and the trial court have cited about the schedule of fines for traffic violations, which has been cited as, what the language that would be needed in order to make it clear that emergency rules could not go into effect pending approval or the deeming of approval by the council. But in our view, that last sentence of the traffic civil penalties for traffic infraction statute is using materially equivalent language as with the last sentence of 61409. It's just that there you have a notwithstanding 2505C clause that kind of makes clear that in the event of a clash, that provision will prevail. But even without that notwithstanding clause, you still have to give a plain effect to the plain meaning of 61409. And it says right there that the rule shall not go into effect until approved or deemed approved by the council.
So can you tell me, I guess, maybe in more plain language, why that language alone in 1409 and 303 in your mind equates to precluding emergency rulemaking in this realm?
I don't think it necessarily precludes emergency rulemaking. It's emergency rulemaking can still do its office of providing an exception to the notice and comment requirements of 505A. It just prevents emergency rulemaking from going into effect right away until the independent requirements of the enabling statute are satisfied. I did want to move ahead, and I see I'm already running low on time, to our other arguments, particularly the argument that substantial evidence does not support the emergency finding here. I think this is another reason why the emergency rule should fall in this case. Basic principles of administrative law require that the record should be limited to that which was before the decision maker. And the record on that is quite bare as to what was before the city administrator at the time the decision was made here.
Would you acknowledge this? Suppose, I'll try not to make this sound pejorative. Suppose we had a true emergency and nobody had time to write a memo to the city administrator. So everybody rushes in, explains things to him orally, and he says, "You're right, let's do an emergency regulation." Would you concede that oral briefings would count as part of the record?
Yes, we have no principled objection to oral briefings. Our objection is to what is actually available, post hoc as to what was before what he was briefed on here. So we have a privileged discussion that has never been really disclosed what the basis for it or what was shared, and then a discussion that not much is known about. The three reasons given were a safety issue, but there's really no evidence, certainly no evidence before the city administrator about a safety issue. And safety issues can always be dealt with on a stop work order. Then there was a concern about traffic safety, fair enough, but no evidence about traffic issues. So we're left with what was referred to as visual blight, or what is referred to more bluntly in the district's brief as these signs are unsightly. They're gaudy. They're just not. They're not aesthetically pleasing. This is an aesthetic emergency that needs to be dealt with right away. Well, if that's the emergency, and even if the court were to look beyond the record before the city administrator to kind of everything available to the district at the time, that couldn't be an emergency we submit. That couldn't be an unexpected development that required urgent action in June of 2016. Why? Because going back to 2010, what's been referred to as the proliferation of quasi-exterior signage, it was known to DC officials that was a possibility under the legacy regulation. There was an emergency rule in 2011 that never was made final.
So you're raising then the issue of what is our standard of review for looking at the city administrator's thought process? And I think we're assuming here, for the sake of argument, that emergency rules are permitted. The emergency rule provision itself talks about in an emergency as determined by the mayor. And so doesn't that require us to give some deference to the judgment of the city administrator?
Certainly, we've not argued for a de novo standard. We think substantial evidence, which was invoked in Hobson, and what we think is a relatively analogous situation is the appropriate way to frame it. It's also been referred to, this court has had a couple of other emergency rule decisions as review for reasonableness. Under any of those standards, I don't even think the court has to settle on that standard here, because the facts of record are this. In November of 2015, even if we just focus on Lumen's signs, in November of 2015, Lumen's plans, the chief of staff, the mayor's chief of staff, receives a presentation detailing the business plans, the purported business plans of Lumen to have scores of signs throughout the district. In December of 2015, the CCCB hears about this at a meeting, and a determination is made that, well, I think we should go forward with a rulemaking. But as the chairperson of the CCCB said, tough to justify as an emergency. Nothing happens for 7 months until June. And when it finally comes to be that they decide to go with an emergency rule, and we cite this in the record, what one DC official says is, well, we should probably go with an emergency rule. And then the basis that we, in one email by an attorney that is a DC official responsible for this area, is that this could get contentious before the council. This could be a subject of debate with industry officials or others, and it could be very contentious in the council. Well, that is democracy. That cannot be the basis for an emergency rule, that it might get contentious and be the subject of democratic debate before the legislature. So we don't think this
I'm sorry, but the emergency rulemaking authority under 5.5 says that, it requires only that the emergency rule be forthwith published and filed, right? And then in 501 of that same chapter, it says that except that this subchapter shall supersede any such law and procedure to the extent of any conflict therewith. Does that language inform at all your view that 505 doesn't really apply to allow for the emergency rulemaking under 1409?
So going back to that, I don't think so, because again, the DC Administrative Procedure Act is not an independent grant of rulemaking authority unmoored from a substantive or enabling statute.
Right, but it's not unmoored here from 1409, which references specifically the 500s of the emergency, chapter 500s of the Emergency Procedure Act. That's why I keep coming back to it. It seems like they are moored or connected or specifically cross-referenced there.
It's true, they're cross-referenced, but if I could take one more crack at trying to convince you why 61409 does not allow the emergency rules that are referenced in 61409, in referencing the entire title, I grant that. But 61409 then keeps going. It keeps going, and it says quite clearly that the rules shall not take effect until they are approved or deemed approved by the council. And so I'm happy to accept your point, Your Honor, that that the provisions of 2505C are part of what is referenced in 61409, but when the statute keeps speaking and then ends with the rules shall not take effect until approved or deemed approved by the council, that is what controls. It has to be that enabling statute that controls.
But what about what about 501, which says when there's a conflict, 501 or the chapter 5 provisions supersede others? In this case, could we read that to be 1409 provisions?
No, I don't think that could be read as 1409. And that's really never been the case under administrative law generally, or even under this court's cases on administrative procedure, which is to say that it is the organics, it is always the requirements of the APA, yes, to the extent they are applicable, but the requirements of the enabling statute that inform the rulemaking, the independent requirements must be followed. And that is the holding in Jubilee, for example, but I think it's just a basic principle that that's the enabling provision. I am with the court's indulgence, I do just want to briefly get in our third argument about the extensions, because I think here, even if the court on the substantial evidence question supporting the initial emergency, the extensions are a particularly stark example of a lack of substantial evidence for an emergency. Now, we think that the better rule would be that seriatim extensions of an emergency are not contemplated by 2505C. You can't just have 120-day extension after 120-day after extension and so on. But even if the court weren't to reach that or didn't agree with us about that, there would still have to be substantial evidence of record supporting a finding of an emergency in order to uphold the rule. And there is no evidence of some new unexpected development that could justify another emergency rule. So in this, let's just take the second emergency rule, the November extension of the emergency rule. There, it's in the emergency rule itself, and this is in our statutory addendum. It says, well, the emergency is because additional time is needed for the council's review. Well, that can't be an unexpected or new emergent development, because it results entirely from the way this was handled. The emergency rule comes down. It takes 98 days for the rule to be transmitted to the council. So now we're up against the 120-day deadline, and it's extended. But that just can't be a new emergency, and you don't have to take my word for it. We cite in our papers and in the appendix the manual that DC officials use when they promulgate rules, including emergency rules. And it has some very helpful language on when a successive emergency rule might be appropriate. And what it says is you need to look for new, it can't just be that you're up against the deadline. It has to be some new development, some new facts that couldn't have been anticipated that require a continuing emergency finding. Well, that's just not present here. And so for those reasons, and unless the court has further
Counsel,
questions.
I just wonder if this last argument about needing more time for council to the council to review the emergency rule is particularly in tension with DC Code 1-30321A, which doesn't have the deemed approved language, right? Which actually requires the council to act. Do you have any thoughts about that?
Well, certainly, if we're talking, if 1303.
Right, under 1409, sorry, just to make my question clear, under 1409, if the council doesn't act, the rule can be deemed approved if 45 days pass. But under 1303.21A, if the council doesn't approve the rule within a certain period of time, then it's deemed rejected, essentially, right? That's what I read that statute to say. So then if you're saying, oh, we need more time to get the council's approval, that seems in direct tension with the statute.
That if we're in 1303.21, then yes, I mean, I don't see how you could have extensions. It would just lapse by the failure to approve within the 45 days.
Counsel, I have a question for you that is probably an issue for another day, but I'll ask it anyway. When the city administrator promulgated the emergency rule, he at the same time announced that they were proposing a final rule and set a notice and comment period. That final rule went into effect long ago. That rule being in effect, what would give your client the right to erect your signs tomorrow?
Well, thank you for the question. And this was an issue that was litigated, not pressed on appeal by the district, but briefed below before Judge Pan. And as we understand it, there was a supplemental briefing sought on mootness, at least as to an injunctive relief claim. And as we argued then, and as Judge Pan accepted, the rules in effect at the time the stop work orders were issued. So if there's no emergency rule, then the rules in effect at the time the stop work orders issued would give Lumen the right to erect the signs. That was part of Judge Pan's basis for dismissing the damages claims. That if the rules in effect at the time the stop work orders issued allowed the signs, then the remedy would be to allow the signs to go up. Now, if there's any doubt about that, or if there's a remand in this case, that could certainly be revisited. It's obviously a voluminous appendix, but I do think that the portion that I'm talking about where Judge Pan addressed this was at a December 4, 2017 hearing on the motion to dismiss after receiving some supplemental briefing about the mootness issue. And she dismisses the damages in part on this basis. I think it is at in volume 6 at 2902.
Thank you.
Unless the court has further questions, I've gone over. So thank you, and I'll reserve for rebuttal.
All right, thank you. And we'll hear from Counsel for Appellee, Ms. Pittman.
Good morning. May it please the court. I'm Lucy Pittman. I'm here on behalf of the District of Columbia. I'm going to start, I think, where the court started with Lumen's counsel, which is the statutory authority. It is our view that the Superior Court got this case correct when it granted judgment and found that the district had statutory authority to issue an emergency rule. The language and to jump in where some of the questions that you had, Chief Judge, with regard to 61409, we do view that the language there and the incorporation of the entire DC APA to include the both the normal sort of proposed rule, notice and comment rulemaking in subsection A, as well as the emergency rulemaking in subsection C of 2-505 has been incorporated. And I think that that last sentence that counsel pointed out is probably a key sentence. And there, I think, again, the Superior Court got it right by showing the one statutory provision that is the best or closest comparator here, which is 502301.05. And there, in a very similar statute that begins by saying proposed rules shall be issued or may be issued under the DC APA, that there's a 45-day council review period, it's a passive review period. And then the last sentence felt the need to carve out the emergency rulemaking power with a notwithstanding 505C. The council would not have included that language in that last sentence if it did not believe that emergency rulemaking power had been granted within the prior sentences. And we think that that is the best reading of 61409 here as well, that without an
Ms. Pittman, I'm sorry. I've seen way too many instances where the council does things differently or inconsistently, trying to achieve a similar result. And are you saying that because 1409 does not have the term notwithstanding in it, that last sentence cannot preclude emergency rulemaking?
I think that the better reading of 61409 is that without some indication from the council that they had intended to carve out the emergency rulemaking powers, it could have been with the notwithstanding statement that I just gave as an example, or it could have been in the earlier sentence. They could have said you may issue rules under 505A and then excluded C. There's many ways in which to do it, but we do believe, and I agree with you, there are lots of different statutory provisions on rulemaking. And pretty consistently, the district has viewed when there is a council review period that is required, that unless that's tacked on and included as part of the notice and comment that would be in 505A. And unless there's an explicit statement saying you don't have the power under 505C, that is power that exists. And I think that makes sense here because the construction code is, I think, a prototypical type of an area where you're going to have safety concerns. And I think
before you move on to that, Usually when one is puzzled about what a provision means in a statute, you go looking for the legislative history. And we've done some of that and so far haven't come up with anything that explains what the purpose of the last sentence is. Are you aware of any such legislative history?
I am not. I came up with similar results to what you have, which is that there's not much there to further explain it. And so I think that we look at it more from a practical perspective of what was the council intending here. How have we interpreted it consistently throughout? We gave examples in the brief of emergency rulemaking power under this provision, and that has been deemed approved by the council without them at all saying, no, you don't have that power. And here we did in fact provide to them both the emergency and proposed rulemaking, so they knew it was open that we had proposed or that we had enacted this rule prior to the council review period. And so I think all of those things indicate and support that where the council really wants to take away this emergency rulemaking power, particularly in an area like the construction code, it would do so explicitly.
But what if we're not under the construction code, right? I mean, what if we're under this seemingly more specific statute that's just dealing with signage? And, you know, whereas I might be more sympathetic in thinking about why you would need to retain emergency rulemaking authority and under the construction code, it's harder to see a signage emergency. So, you know, if you just read the plain language of 130321A, it really kind of says this is the only way that you're going to get rules approved by the council for signage. And you have to get the council to look at them and approve them. There are no shortcuts, right? We actually want the council to look at these things.
So I have to begin with an apology, Judge Easterly. I did not receive the order on Monday, and no one in my office did either. I have very much no poker face, so you probably saw my expression when it was mentioned earlier. And so I apologize. I'm not prepared today to discuss 303 and the legislative history that exists there. I will say that here the emergency rulemaking that was put forth was 6-1409 as the authority that was used. And I do know sort of from this record that Judge Fisher is correct, that there's been a lot of legislative changes, in particular, one of which would be to take the sign code out of the construction code, but it is not currently removed from the construction code. And so 6-1409 still does apply to the sign code as a part of the construction code. And so I can say that if you want like further briefing on that, I would be happy to do that, but we did not receive that order. And so I apologize.
Well, I don't have a poker face either. Yeah. I did not see your expression earlier, and you probably just saw mine just now. Yeah, I would have questions for you about how to read the two statutes together, because it seems to me it's not feasible to read these two statutes together, given that one deems rules to be approved by the council's silence and the other says, no, silence doesn't count. The council actually has to approve them. So it seems like one would have to pick between the two rules, but I won't press you on that point because I understand that you haven't had the benefit of seeing our order or reviewing the statute with some time to give a thoughtful answer.
Ms. Pittman, if I recall your brief correctly, you have argued that we should give some deference to the district's interpretation of 1409. I'm having a little trouble warming up to that idea because I don't see this as a matter of practical substantive expertise as much as just plain old vanilla statutory interpretation that we can do maybe as well as you can.
I think embedded in that argument is that this is something that the district has consistently used when it, thankfully there aren't that many construction emergencies, so I need to be careful about saying too consistent, but we did provide examples in the brief of using emergency rulemaking in the construction code, and that the council has not gone back and changed this provision. And that I think that this would be a sea change to say to the district that it does not have emergency rulemaking power that it has exercised before, and that the other legislative or the other governmental branch has not gone back and changed the law to make sure that we understand that we don't, if that was their initial intent. And so it's more of it's more along those lines rather than, I think, your traditional agency expertise deference that we see in these cases. I also,
So as I translate that, I think you're saying it would really hurt if this court were to rule that 1409 does not allow emergency rulemaking.
I think it would be pretty inconsistent with things that have taken place in the past and the interpretation that the district has taken for a number of these statutory provisions that require a council review period as well. And that is generally speaking, unless the statute speaks to the emergency rulemaking power, otherwise has been viewed as being tacked on to the proposed rulemaking with the notice and comment, so that it's before the rule is become final that you do the council review period. I do want to circle back because I think it does to something that Judge Easterly said about safety and signs not maybe being the typical safety concern. I think that the record here, and this bleeds into the next set of arguments, is that there are serious safety concerns when you're talking about exterior heavy signs being mounted to the exterior of buildings. And I think the city administrator—
Is that in the record though?
Yes, the city administrator testified to the fact that the then director of DCRA spoke to him about safety concerns, spoke to him about where the signs would be placed. He saw a list of where the signs would be placed, some if not all of the signs. And he spoke about the concern that the signs could fall on pedestrians. He also talked about the illuminated signs being a distraction to drivers. And then it was actually the third thing that he talked about, which was the visual blight. And I don't want to make light of that because I think visual blight can be a devastating effect on a neighborhood. But his first two concerns were pedestrian and traffic safety, both of which I think do bear out when you're talking about signs being mounted exterior to a building and that have not been through a permit process. The permit process is what ensures that they are safe or at least goes through a safety check. And I disagree with counsel that the record is bare on that. The city administrator, he testified to the conversations he had with the director of DCRA. And I think the Superior Court got it right when it said that the record changed dramatically. And I want to say June 21st was the date when all of the emails came in, and it became abundantly clear that Lumen was building signs without any oversight whatsoever. And in fact, intentionally without oversight from DCRA. And so I disagree that and that record is there.
Can you just generally direct me to where to review that part of the record?
Sure. So I think probably the easiest is to look at the Superior Court's order where she does cite to all of those emails. Our brief itself has those, and I don't have an immediate citation for you, but it is the emails. It's all late June when those emails starting June 21st. It's when the deliberations occur, and the Superior Court goes through great detail on each one of those. And then in terms of the administrator, I can say the appendix 356. And right around that area is his deposition testimony where he goes into detail about his concerns and what he knew.
Ms. Pittman, Mr. Serretta makes the argument that, or I should say, seems to make the argument that unless there was a clearer link to the fact that the city administrator had read all of the emails, that they shouldn't have been considered a part of the administrative record. And I guess that argument doesn't I'd like to hear you speak to it because I'm not sure that that resonates with me. I mean, city administrator is the senior administrator. And all of the other department directors report to the city administrator. And if the city administrator is the implication of the city, unless he reads every single thing that every single department head said about the signs himself, that the recommendations he receives from oral briefings from general counsel and one agency head are insufficient.
So I agree with you. That probably won't surprise you, that the city administrator should not be tasked with having to read everything in the record. And as I hear Lumen's counsel say today, he's not objecting to the concept of there being an oral briefing, which is what occurred here. The director of the Department of Consumer and Regulatory Affairs briefed him on the safety concerns. So she basically came to him and said, we have a problem. She defined the scope of the problem. She told him what the safety concerns were, and she gave him what they proposed solution. And I think that is a normal thing you will find with decision makers. And so it is appropriate to take a look at what she knew, what some of the other high level people knew. We're not trying to define this as being everything that the Department of Consumer and Regulatory Affairs knew. That I agree would probably be too much. But it is these high level employees who are then making the determination as to whether or not to recommend that an emergency rule be implemented. I also think it's
I wanted to pause on what you just said. I've wondered whether Judge Pan maybe spoke a little too broadly when she talked about the record she would consider. And she said the court will consider all of the relevant information considered by the district broadly defined. I think I heard you pulling back a little bit on that just a minute ago. Is that correct?
I don't think it needs to be as broad as she defined. I think there probably could be cases where I might be arguing otherwise, but I don't think it needs to be. It's not, this case is not one of those. What Judge Pan relied on in her order was a subset of information from these high level individuals who were the ones who are actually making the determination and the recommendation, I should say recommendation to the city administrator.
You're saying the record in this case should consist of what people said and were thinking at this time when they were making recommendations to the city administrator. Is that roughly correct?
It would also include what was coming into them that prompted this. And I think that that's
Right.
what's really key here are the complaints that came in with the real life information that the signs were going up and they were going up eminently. And that is the information that's starting on June 21st, you see where things change dramatically, where it's now no longer a theoretical problem that council was discussing from late 2015. This was a real problem with real consequences and being done in short order. And it is that record that then goes to the city administrator for his approval of the emergency rule. And I do think that that's probably worth noting. No one is challenging the content of the rule itself. So it's just his emergency determination, whether or not there's a problem today that we need to get a rule in place on. And so you don't need a very extensive administrative record for something like that. You need to know that the signs were going up, they were going up in very short order, they were going up unpermitted, meaning that they have not had any safety evaluation, they pose a safety risk, and something needs to be done in short order. And so that is the determination that the city administrator made.
I wonder if we could talk for a bit about successive emergency rules.
Sure.
And in your brief, and I think in your opponent's brief, there's a tendency to talk about something that's very similar, that is successive emergency legislation. And I'm wondering if those are fair analogies, because in the legislative context, two branches of the government have agreed that they want to do this. Whereas in this context, to borrow a phrase from your opponent, it's unilateral. The city administrator's doing it. So are those fair comparisons?
I actually do think that the comparisons on emergency legislation and emergency rulemaking in this context is very very analogous. And I'll actually just refer this court to its decision in US v. Alston. There was an explicit question of, can you have successive emergency legislation, where the statutory provision says that the legislation will not remain in effect for longer than 90 days. It's very similar to the DCAPA language, which says that the emergency rule will not remain in effect for longer than 120 days. This court in Alston said explicitly that language by itself does not prevent successive emergency legislation. And then it went on to explain why home ownership, a prior case that said you couldn't have successive emergency legislation, was really based upon a very specific factual issue of they were trying to avoid congressional review by doing the successive emergency legislation. Here, we do not have anything to indicate that we are trying to avoid notice and comment rulemaking, which would be, I think, under the normal sort of set of circumstances, or here where they have also the council review period. There's nothing to indicate that the council review period was trying to be avoided. This was not a separate rulemaking track that was being used. And there, I will pause for a moment just to take issue, I think, with council's timeline. He seems to imply that that the city just sort of sat around and didn't do anything after it issued these emergency rules. I think that's quite to the contrary. The emergency rule was published in late August. It was published for a 30-day notice and comment period. So we weren't trying to avoid any requirements. That notice and comment period ended at the end of September. A fiscal impact statement was then generated, dated October 11th, and that then went with the package on October 18th to the council for the council review period. It was still within the 120 days, but it would expire that 120 days before the 45-day council review period would be done. US v. Alston speaks directly to the fact that a second emergency, in order to ensure that you don't have a gap in the law, is a sufficient basis for an emergency. And so I take issue with Lumen saying that there isn't justification for a second emergency. There absolutely is. You needed to review to complete the council review period and not have a gap in the law.
Let's talk about standard of review. How do we review the city administrator's determination that there was an emergency? We've got only a couple of cases dealing with emergency rules. It's kind of vague where their standards came from. Let me start by asking, is there a statute which tells us what our standard of review ought to be on the decision that there was an emergency?
One is not coming to me immediately outside of the DCAPA's standard, which is deferential. And I think that that's what you start to see in some of the court's opinions, that it is a deferential standard in which you look to see if basically the relevant facts support the agency decision. And so some of the case law talks about, is there a rational connection between the facts and the decision? And so I think the question would be then for the court to determine, is there a rational connection between the fact that we learned in late June, these signs were going up, they were going up quickly, and that they posed a safety concern, with the decision to then say that there is an emergent reason to have a rule in place. And it is
all that sounds pretty familiar as review of administrative action. In the Jubilee housing case, we said something kind of offhand like reasonable under the circumstances. Do you think it's more complicated than that?
I don't think it's more complicated than that. And I think that the court's decision in Hodson also relates to, again, emergency legislation. There, the record supporting the emergency is similar to, if not less, compared to what we have here. They had an emergency situation where there wasn't a law, a criminal penalty for paying a bus fare. And so people stopped paying their bus fare. So they had an immediate situation that they needed to address. And they had a recommendation from a deputy mayor. They had evidence on the ground that it was happening right now. And they had a corporation council opinion saying that it was okay to do. And that was, according to this court, that was a fully established emergency, or fully supported, I think was the language that was used there. And I think that similarly here, the emergency is fully supported based upon what we know in this record and in the city administrator's testimony. If there are, I have one further thing but if there are further questions on that, I just wanted to briefly touch on, council implied that there was some attempt to try to circumvent the council here because it could be contentious in the council. I think that the evidence bears out that that's simply not what was trying to be avoided. And in fact, the rule was placed before the council very promptly for their review. So the fact of the matter is it was done as an emergency and a proposed rule at the same time, following all of the various requirements. I do see my time is up, and so if there are no further questions, I will ask that the court affirm the Superior Court's judgment.
All right, Ms. Pittman, at the risk of prolonging this, you may have addressed it earlier, but I'm not sure if I'm clear on what your response would be to the questions I asked Mr. Serretta earlier about the interplay between 61409 and 2505 and the emergency legislation. Is it that the emergency legislation could run along parallel track to full permanent legislation? Number one, and is there an interplay, I guess would be the foundational question. Mr. Serretta, as I understood it, has said no, because 1409 prevails or supersedes. I don't want to put words in his mouth, but that's how I understand his argument.
Sure. So 1409, and I also don't want to put words in his mouth, but I think that he would agree that that 1409 does include the DCAPA requirement, because otherwise we wouldn't have the notice and comment requirement in 505A, but for that language. And so it is our view that the incorporation of the DCAPA in that provision incorporates both 505A and 505C. And we really do think that the Superior Court got it right by using the comparator of set forth in the traffic adjudication cases 50-2301.05, which I think further defines or reflects on the fact that 505C is incorporated into the mayor's authority in 61409. I hope that answers the question. If not, I'll try again.
Thank you.
Okay.
Mr. Serretta, we said we would reserve a couple minutes of rebuttal for you.
Thank you, Your Honor. I appreciate it. Just to start there with the interplay between 2505 and 61409. We do agree that it references, counsel was not putting words in my mouth. We do agree that it does, of course, it references and it makes reference to 2505, and that includes all of 2505. So you can have notice and comment rulemaking, you can have emergency rulemaking that provides an exception from the notice and comment requirements. All we are saying is that the last sentence of the statute, 61409, still has to be given some force. It has to mean something. The rules shall not take effect until they are approved or deemed approved by the council. That just can't be read out of the statute or rewritten to mean the rules may take effect before they are approved or deemed approved by the council. There are a lot of statutes that authorize similar review periods, and we cite many of them in our briefs. I tried to do a more comprehensive review in preparation for this argument. I found something like 180 different statutes that have a review period, pending council review period. I only found 3, as I said during the opening argument, that have language anything like this last sentence. So there's a bunch that expressly reference emergency rulemaking. They say after 45 days, they shall be either approved or deemed approved. And then there's and then there's a subsection right under it. Notwithstanding the above, you can do emergency rulemaking that takes effect immediately under 2505C. That's not here. Now, there is a lot of statutes that are a sort of middle case where it doesn't have the express reference to emergency rulemaking, but it doesn't have anything like our last sentence in 61409. And I think those are a harder case. What I don't think is a hard case is a statute like this, or like 1303.21, or like the traffic infraction statute 502301, that says in plain language that the rules do not take effect until they are approved. I recognize I'm out of time. I want to respond to one point on the emergency and in particular on the safety issue, because it's true, safety is mentioned at the deposition as an issue, but in all those emails, there's no actual, even if we look at the record broadly and say, okay, what was the city administrator briefed on in summary fashion in the oral briefing? There's no safety evidence in the record other than there are signs going up. So safety, we think, cannot be a basis for this rule. And the reason we know that it's not a basis for this rule is that there was never a need for an emergency rule based on a safety issue. We cited in our brief, but it's already in the building code. You can have a stop work order if there is if something is being put up in an unsafe or dangerous manner. That's in the building code 12 DCMR 114A. So safety is not the basis. There's no evidence that traffic is the basis. It's the aesthetic concern. And that aesthetic concern is known to the district months and months in advance of any move to enact an emergency rule. It's there in November. It's there in December. No steps are taken until June. Unless the court has further questions, we would ask the court to reverse and remand. And thank you very much for your time.
All right, thank you. We appreciate both counsel's briefs and arguments in this case. I'm going to ask whether my colleagues have any need for any supplemental materials before we adjourn.
I would be in favor of requesting supplemental briefing. Maybe we should discuss that in our conference, and we'll issue an order that we'll try to send to Ms. Pittman as well as to Mr. Serrata.
All right.
We do try not to play favorites.
I am pro hoc vice in this case, and I received it by email, and I think that was a problem, and I'm sorry that happened.
All right. Okay, well, you'll hear from us with respect to whether and what additional we may need from you. Thank you, counsel. And I think our courtroom clerk is going to adjourn us.
This court is now adjourned.
All right, counsel, you're free to exit our virtual courtroom. Thank you.